Hello everyone. My name is Mirunaaleni Selvaraju. I am actually a medical doctor currently pursuing my postgraduate study in the field of public health. As part of my studies and assessment, I have the task of creating a video to address the topic of updates in epidemiology in other fields. This video of mine is being assessed by my lecturer, Associate Professor Dr. Helmi bin Hazmi. So, what is epidemiology? Epidemiology is the study of the distribution and determinants of health-related states or events in populations and the application of this study to control health problems. Epidemiology is the basics of public health. It plays a significant role in not only identifying individuals at high risk for disease, it also plays a role in recognizing and control epidemics, monitor rates of disease and exposure in populations, and also it is a concept that is widely used in other fields. Its concepts are largely utilized in fields such as molecular epidemiology, pharmacoepidemiology, occupational health, environmental health, and many other conditions. Today, what I am sharing with you is the use of epidemiology in the courtroom, which is known as forensic epidemiology. So, how does epidemiology play a role in the courtroom? Epidemiologists have been called upon often in the past few decades to help to resolve disease-related litigations. They have served as investigative experts, consulting experts, and expert witnesses. Aside from that, epidemiologists have been used to interview case patients to explain the scientific principles underlying a particular matter, to explain statistical principles for analyzing study outcomes, and to present data collected on the exposure and the outcome which is being under scrutiny. So let's look at let's now look at a sample of a case that happened before. In the year 1999, Sally Clark, who is a British solicitor, was convicted in United Kingdom court for murdering two of her children. Both of the infants died within weeks of birth under the circumstances originally diagnosed by some experts as sudden infant death syndrome, SIDS, or also known as cot death. An important witness for the prosecution was the prominent pediatrician Sir Roy Meadow, who testified that the probability of two cot deaths in one family was exceedingly remote at about 1 in 73 million. The meager probability that the deaths were due to natural causes was used by the prosecution as evidence that the deaths were actually homicidal. In the Clark case, the estimate of 1 in 73 million was derived from squaring the observed risk of a single cot death in an affluent non-smoking family, which was then estimated at 1 in 8,500. Meadows' testimony created a furor among statisticians, with the president of Royal Statistical Society writing an open letter of complaint concerning the error of allowing non-qualified experts to testify regarding unsound statistically based arguments. The guilty verdict was appealed based in part on the problems with Meadows' statistical claims. The conviction eventually was overturned. So now let's look at what's wrong in Meadows' method of calculation of the probability. Well, the primary complaint with Meadows' testimony was that from a statistical perspective, he treated the specific risk to the Clark family for cot death like they were a randomly selected family with no predilection for the event in question. In other words, Meadow considered the one family in 8,500 with a cot death to simply be unlucky, with no biological or environmental diathesis for the condition, rather like the probability that one will roll a 6 with a die. Thus, according to Meadow, the second death was no more likely than the first, just like as second 6 is more likely than the first, and the probability of each can be multiplied to arrive at the probability of the both. The tragedy of the Clark case raises the question of how such a chain of events could have occurred. How could testimony that is fundamentally flawed be used to imprison an innocent person? What is apparent from the many different experts from a variety of disciplines who gave opinions regarding the faulty testimony in the Clark case is that not only is there uncertainty regarding what constitutes valid testimony on some issues, but there is also a degree of uncertainty as to who should be setting the standard for such testimony? Any expert opinion that addresses the probability, risk, incidence, or prevalence of an event occurring or not occurring in an individual or a population is an opinion that must have a foundation in valid epidemiologic concept and data. Therefore, the proper application of epidemiologic concepts and data to forensic issue is the practice of forensic epidemiology, FE. So let's move on. Let's look at what scenarios in which experts use concepts of epidemiology in forensic. The use of probabilistic language is inescapable in the forensic setting, since the standard for admitting expert testimony is that it is rendered as being more probable or likely than not, or as a reasonable probability or reasonable medical probability, all basically relatively interchangeable terms. Probabilistic opinions may be expressed in terms of incidence of an occurrence or condition, prevalence of an occurrence or condition, or risk of an occurrence or condition. Let's look at one example. Opinions involving risk often rely upon probabilistic language, and this in turn may lead to a lack of specificity. For example, it is reasonable to opine that not wearing a seatbelt increases the risk of ejection in the event of rollover crash, an important determination in some forensic venues, as it may indicate contributory negligence of the occupant to his or her own injuries for failure to wear a seatbelt. On the other hand, if the occupant was not wearing a seatbelt and was not ejected but still fatally injured, the presence or absence of a seatbelt is a significantly smaller factor for injury frequency and severity, particularly if there is a great deal of vehicle roof crash that may have resulted in severe head and neck injury to a properly positioned and restrained occupant. Quantification of the difference in risk of injury between the two scenarios would be important in helping for a fact finder for the judge to determine whether the lack of a seatbelt was a significant factor in case in question. So now let's look at another example of courtroom use of epidemiology. Retinal hemorrhage in an infant is a reliable indicator of shaken baby syndrome. This claim sounds like an estimation of point prevalence, but in fact it is a statement of prevalence ratio, also known as odds ratio, as it implies comparison of the finding of retinal hemorrhage in violent assault versus some other trauma. Because many shaken baby syndrome homicide prosecution are defended with the assertion that the injuries resulted from a fall or some other precipitating unintentional trauma, the claim implies that the incidence of retinal hemorrhage in infants that have sustained an unintentionally self-inflicted injury is very small at or near zero, and the incidence of retinal hemorrhage in infant victims of assault is significantly higher. As a hypothetical example, it might be said that only 1% of infant fatalities that result from an unintentional injury result in retinal hemorrhage, whereas 75% of the confirmed case of shaken baby syndrome have the same finding. Thus, a finding of retinal hemorrhage is at least suggestive of homicide in the absence of any other evidence. Let's now look at the principle of applied forensic epidemiology. When there are questions regarding causation of injury or multiple potential causes or unknown outcomes, the probability that one cause play a greater role than another must be weighed, and this often requires the interpretation of data derived from epidemiological study. Standards for epidemiologic determination of cause and effects were first laid out in a systematic fashion by Hill in 1969. Hill outlined 9 criteria by which determination of causation could be made when there is substantial epidemiologic evidence linking a disease or injury with an exposure. The criteria have been since modified and distilled by others. They comprise all the following 3 elements, which are: there must be a biological plausible link between the exposure and the outcome, there must be a temporal relationship between the exposure and the outcome, and also there must be not any likely other explanations for the symptoms. So as a conclusion, what we can say is that forensic epidemiology has been used for many years in the courtroom and public health, as well as law enforcement, have conducted joint investigations of many health-related criminal events, and this field is still growing progressively. Thank you very much for listening. Have a great day. Bye-bye.